Greetings to all learners. Myself Sharda Devre from Government College of Pharmacy, Amravati, Maharashtra. Welcomes you to Lecture 30, Case Study 10, Demonstration of Patent, Geographical Indication, Trademark and Copyright Registration. So here we have to learn about the registration procedure for the patent, trademark, geographical indications and copyright. In previous lecture, we have learned about the various types of the intellectual property rights, how they help to protect the various inventions under the various titles, and thus they give us the reward as well as the recognition through the various duration terms for the protections, and exclusive rights are also granted either to the individual or to the group of the individual. So we will start with the Google search for the Indian Patent Office, that is IP India. When you will type it in a Google, it will take you to the official website of the Intellectual Property of India. This is the website where all the details of patents, designs, trademarks and geographical indications are given. They have all the quick references and all the other guidance are given through the FAQs also. So first we will start with the patent registration. When you are aware, or when you come to know that whatever the research you have done, it is a invention and not a discovery, means when it is very technically advanced, and which is not means which is out of the thinking of the common skill persons, then such a type of the research can be filed for the patent. So when and how this type of the research can be filed as a patent, or when my invention can be patented, for that you must have the a certain type of the clarity. You must have the group of the friends as well as the mentors as well as the teachers, means with teachers you must have the discussion, and so that these people can guide you whether the that particular research that you have done is invention or discovery. When it is confirmed that it is an invention, then you can write about it in some like a paper article, or like a synopsis of the research. You have to write everything. Here I am showing you the one patent, that is I have searched through the Google. Here it is from the European Patent Office. Its application dates and status, everything is mentioned. Here you can see that you must have the abstract written. Then after abstract, there must be the description, the technical field of the invention, means the invention can be related to the biotechnology, chemistry, it can be related to the life sciences, it can be related to the biochemistry. Then about its background, that what background means generally the prior art, that what people are doing, and what type of the uh, uh, problem need to be solved, that is not solved till date, must be mentioned in the background. Then summary of the invention need to be given, that what your invention is about. Then brief description of the drawings, if there is a device, if there is any type of the chemical reaction which is giving you the new product, or if there are the any type of the other type of the inventions which are involving the drawings, then detailed description of the drawing should be given. Then detailed description of the embodiments. So whatever the uh, figures, tables, graphs that you have added, that need to be mentioned in detail, that how or for what they are added, how they are giving the uh, idea about the invention. Then after this, means after the title, then the background or technical field of the invention, then summary, then the drawings or various embodiments, then the claims are need to be written very carefully. Claims decide the boundary of the invention. It gives you the means suppose you are claiming the 10 means if you have written the 10 claims, then might be 8 claims will be granted to you, or all 10 will be granted to you, or only 3 will be granted to you, or even only one can be granted, or otherwise patent can be rejected by the patent office. So there can be many chances, but the claim drafting is the most important part of the patent drafting. Then whatever the citations that you have used, either patent publications or other articles, newspaper or book references, so everything you have to mention. So this way, if when your data is ready like that, with a title which should be less than 15 words, then the various means methods that you have used, and from that the best method of invention which you can mention in the summary of the invention, then background or prior art, that what people have done till date and what new you have come up with in this invention. So everything when it is ready to you, then as per this Indian Patent Act 1970 section 10, you are preparing the contents of specification. Now for filing the patent, either you required the patent agent, lawyer, or by yourself you can file the patents. So there is not always necessary that it should be filed by the lawyer or the patent agent, but sometimes or it happens many times that most of the inventors are not aware about the various technical details of the patent, trademark, or geographical indications or design filing, and hence from that point of view it is always better to file the patent or file the geographical indication or trademark through the patent agents or through the lawyers. Now here this IP India, there is this comprehensive e-filing is mentioned. Before that we will means, as we have seen that what should be in a specification, we will see that which forms and fees will be required. When your detailed description, detailed specification is available, means you have draft the complete patent either yourself or with the help of the patent agent or lawyer, then next it is that the various forms that you need. So here they have mentioned the various forms, that is fees as well as the forms. You can see it is mentioned in under the administration part of the patent, forms and fees. Generally form 2 1 2, that is application for the grant of patent, then provisional or complete specification in a form 2, then this declaration of the inventorship in the form 5, then publication, that is in the request for publication in form 9, then request for examination in form 18, and one more form if it is through the patent agent, then form 26, that is authorization of a patent agent or any person in matter of proceeding under the act. So there are total 31 forms, but out of that initially you required the some major forms like the form 1 2, then form 5, then if you want means at the same time of the filing you want to file the request for publication as well as the request for examination, then form 9 and form 18, form 9 and form 18. If expedited examination you require, that we fast examination need to be done, uh, there are certain cases for which it is applicable, so form 18A. Otherwise just form 1 2, then 5 and 26, form 26, that is through the patent agent, these are sufficient forms. Later you can submit the form 9 or 18 or 18A, that is possible. So these forms and their fees are mentioned here, that how much fee you will require according to the pages. Means here the fees is mentioned for e-filing as well as for the physical filing. So here they have given the relevant form, the form 1, then how much fee, then we can see that form 2, that is on filing the complete specification after the provisional up to 30 pages. This is for but when you are filing it first time, then 30 pages and 10 claims, you will have this much of the fee addition to the each claim, you will have the additional fees. Even additional pages, you will have the additional fee. So like that they have mentioned everything. When you will go through these details, you will come to know that how much fee you have to pay. Now here, as we have seen that forms and fees and what content should be in a complete specification, next is that how we can do the filing. So here we have gone through the gateway, which is mentioned e-gateways. Under that comprehensive filing, under that we have to uh, click on a e-filing of the patents. They have also mentioned that e-filing trademark, e-filing design, e-filing geographical indications. But now just we will go to the e-filing of the patents. They will take us to the another website. So here you can see that this is the e-filing portal, where you can see that e-sign and DSC, that is a digital signature. Either of the way, either through the e-sign, that is through the KYC Aadhaar card number, or through the DSC that you can register through the chartered accountant. Through that sign you can file the patent. So first you have to register, and then while filing you have to submit the form 1, 2, 5, 26, or required then 9, 18. So it is depends upon your choice. And whatever the content, either I have told you that is a title of the invention which should be less than 15 uh, words, then further the abstract, then background, that is called as the prior art, then technical field of invention, then next it is the uh, summary. In that, best method of invention need to be disclosed, then embodiments, drawings, figures, charts, graphs if there are any, then various claims and references that you have used. So in detail you can do it. If you are filing it, you can file it through this, or when patent agent is there, they used to file nowadays through the e-filing procedure only, instead of that posting the hard copies of the forms and all these things. So this is way you can register for the patent. Next, we will learn about the trademark registration in India, and for that same we will search in the Google, that is a trademark registration procedure. So here again we will try it through the official website, that is the IP India. Here through the trademark registration search, we will go to the official website, where they have took us to the directly to the trademark. Here if you are going to the IP India website, intellectual property office of the India, then you can go under the trademark. Here you will see all the details. Now we have already learned that what is exactly the trademark. So the trademark is the sign and symbol, which, or a combination of it, which can tell us about its quality, its services, uh, either product or services. There are the trademark offices like the patent offices, which are situated in Mumbai, Ahmedabad, Kolkata, New Delhi, and Chennai. And their jurisdiction, territorial jurisdictions are also mentioned. So according to that, if you are from Punjab, then it will be in a New Delhi. If you are from the Karnataka, then it will be the Chennai office. If you are from Maharashtra, Mumbai, Chhattisgarh, Mumbai, Goa, Mumbai office, Madhya Pradesh, Mumbai office. So these territories that are mentioned, according to that, the whoever the applicant is from that particular area, so according to that it will be considered in that territory. Nowadays for patent also it is not necessary to go through that territorial jurisdictions, but it is mentioned Now, under that, first we will try to learn that what are the administrative steps that are involved. So once you have decided that this type of the word or this type of the symbol or combination of the colors or like that, you want to come up with the particular design which is having the certain name or tagline or just a symbol with the different color combinations, then you have to approach to the trademark agent or the like that of the patent agent, or by yourself also you can register it. For that purpose you should have the image of that trademark, uh, and that image you have to submit it to the head office or the branch office of the trademark registry, within whose territorial limits the principal place of the business of the applicant is situated. The digitization and formality checking of the application is done at the respective offices, means all technical details that whether which form you have submitted, whether relevant information of applicant is there or not, number, mobile number, email id, address, then which means the particular uh, other technical details of the form can be verified. Further, it is examined that whether the relevant mark is capable of distinguishing the applicant's good or services, or whether it is prohibited for registration under any law for the time being in force, because there are certain marks which we cannot means have the registration, like that of the army related or some type of the historical monuments related trademarks, or their war associated symbols, or such a type of the trademarks which can be uh, means which can be likely to affect the uh, issues with the particular religion, or they can affect to the sentiments of the people, then such a trademarks or such a symbols or signs cannot be considered for the trademark registration. Then the earlier identical or similar marks which are registered in the trademark registry, then that will be also get verified to avoid any type of the confusion. And then further, these examination of all application is done centrally at the head office of the trademarks registry at Mumbai. Then after examination, the registrar, on consideration of the application and any evidence used or distinctive news, decides whether the application should be accepted for registration or not. And if accepted, then it is published in the trademark journal. We have seen that in case of the patent also, the patent is published. Similarly, trademark is published, and then within 4 months from the date of publication, any person can file an opposition. In such cases, the opposition proceeding is conducted at respective offices of the trademark registry, and under opposition proceeding, a copy of the notice of opposition is served to the applicant, who is required to file the counter statement within the 2 months of filing. So if it is not filed, means if the applicant is not filing the counter statement, then it will be considered as a abandon. Okay, means it will be considered, or it will be not get registered. And if the counter statement is served to the opponent, then with the support of the evidences or with the support of the affidavits, then by hearing the both sides, the examiner or that head of the office will decide to whom the, or whether the trademark is need to be approved or not. Then further, the decision can be appealable in the intellectual property appellate board or the high court. Nowadays intellectual property appellate boards are not there, so high court can be uh, means it can be, decision can be appealable to that high court. Next, it is that there are certain type of the trademarks which are also considered as a list of well-known marks. Means like that, most of the time we say the to the Xerox, actually it is the, means it is the photocopy, but instead of photocopy we say Xerox is the trademark. Similarly, Bajaj, which is the name, Bata, Bains, Distillery, Nowadays we are not saying that it give me the mineral water or water bottle. Instead we say they give the Bisleri. Actually Bisleri is the trademark. So in this way there is the list of the uh, well-known trademarks, means it is called as a trademark dilution also, and these trademarks are considered as a well-known trademarks. That list is also given, so it is just for your information. But here we can see that further how we can file it for the trademark. So before that, it is necessary to understand the various types of the trademarks, or in which or under which it should be get considered. So classification of goods and services, it is mentioned here. You can see that under which class your trademark should be get considered. So here when we are searching the term milk, then you can say that there are various classes. Suppose for milk, milkshake, powder milk, milk solids, milk powder, dried milk, 29 is the class. But milk processing, 40 is the class number. For milk coolers, it is a 11. For milk drinks, again 29. For milk pans, it is a 21. Suppose again I am searching it for the uh, suppose you are in the business of the pen, then we'll search. Suppose the pent, that is for 2, pens for 2, penting for 37, pent balls 28, pen brushes 16. So there are so many different types of the uh, classification of the goods and services are mentioned by the uh, IP India or Intellectual Property Office of the India. Now here also you can do the e-filing, or you can do the offline filing also by document submission to that particular office. Also you can do the filing, and for that also the fees are mentioned, forms and fees are mentioned. So here are the forms, that is application for registration of trademark, collective mark, certification mark, series of trademark for specification of goods and services, which include one or more than one classes. So I have shown you that what are the different type of the classes. So that form is a TMA. The form is TMA, and the fees are mentioned here. So fees for each class and for each mark. So this in a INR, that is Indian rupees, the fees mentioned. If you are notice for the opposition, then what fee should be there. Now we have seen that there is a certain duration term. So after the 10 years you have to do the renew. Well, and for renewal, what amount of the fee and which form, that is a TMR, that is renewal. TMO means opposition. Then application under section 45 to register a subsequent proprietor in case of assignment or transfer for each trademark. Then the TMP means most of the time in a business proprietor changes, so according to that the trademark can be transferred to. So these are the different forms that are mentioned. Then request for search and issue of a certificate, that is a TMC. So extension of a time, duplicate registration certificate, then TMM. So these are the various forms and fees are mentioned on the website. Here then on application to register to the register a trademark for a specification of goods or services included in one class, that is a TM1. Then on application to register a textile trademark, then TM22. Then goods and services included in a class from the convention country, then TM2. So according to that they have mentioned the various forms. You can see that there are more than 70 to 80 forms, and according to that, schedule 1 or first schedule or second schedule, and according to the requirement the forms can be submitted along with the detailed results. Then startup in the trademarks, that is again the external website, which is specially designed. It is not working now, but it is specially designed. Uh, some type of the concessions are given to the startups in patents as well as trademarks. Why this is so? Because they should get the motivation, and number of manufacturing units, number of startups should start in India. From that point of view, these particular facilities are uh, amended, or schemes and policies are implemented by the government of the India. Other detail things are mentioned, like that trademark agents, or publication of the trademarks on the trademark journal, in a trademark journal. I have mentioned, shown you the classification of the goods and services. Then public search is there. For e-filing, I have told you that for e-filing also we can go, and the same that you have to do the first online registration. And for that also you can use the e-sign, or that is a means a digital sign, or KYC and like that. And all the details manuals uh, mention for the e-filing of the trademarks, that you can do by your own, or through the with the help of the lawyer, or the uh, trademark agent, not the patent agent. Then any type of the fee, either for trademark registration, patent registration, or patent filing, or the geographical indication, you can pay the fee through the Bharat Kosh. That is a new payment gateway, and for that also, which is very easy, we can handle most of the government transactions are generally through the Bharat Kosh. So thus here we have learned that what is, or how we can do the trademark registration. We must have that image, or that details of the trademark, and then through the required form with the required information, you can file for the trademark, either through the e-filing, or through the offline filing directly to the office also, it is possible. And then they will give you the legal certificate. These are the publications where TMR journals are there. List of well-known trademarks is also there. Even the list of trademarks or marks which cannot be registered, that is also given on the website. These are the registers or rosters, sorry, registers in which it is mentioned. These are the international non-proprietary names that are also listed here. These are the non-proprietary names, WHO publication references, which are for your information. So you can consider it. This cannot be registered for the trademark. The guidelines are also given, that trademark application SOP for the trademark application. Then all we know that, or learn that Madrid protocol, which is specially for the trademark. Here we can see that what what is mentioned, that is how to do the trademark registration, filing, then Vienna codification, then examination of the applications that we have already considered under the administrative processing, then post advertisement if there is any opposition, so that we have learned. So everything is given on the website. We just have to go through that forms. When we open the form, suppose in a forms and fees, if we are opening the form, then you can see that the nature of the application, means whether the standard mark, trademark, collective mark, certification mark, or the series mark or service mark might be. So that, sorry, series mark, yes, means number of when the business or mm, different type of the services are there, then that type series marks. Then B, in case of the collective mark or certification mark, the draft regulation with the form TMM must be submitted. Then the fees, then the applicant name, then trading as a, then address, address of the service, mobile number, email address, nature of the applicant. Nature of the applicant means whether the applicant is a company or any firm, or whether it is an individual, whether it is society, whether it is private limited company or association of persons or Hindu undivided family. Then applicant's agent, if is there, if any. See, it is not required always. If you have appointed an agent, then only information. Then trademark, category of the trademark, whether it is a word mark, whether it is a device mark, then whether it is a color, means which type of the color or combinations, then three-dimensional trademarks, sound, that all. Then description of the mark which must be provided, means whether we how it is exactly, color combination as well as the shape and all that. Then if marks in a language other than Hindi or English, then that language and its translation either to the uh, Roman script or to the English. Then conditions or limitations to use the trademark, if any. Then class of goods or services, which I have shown you that there are the different classes. Like I have searched for milk and as well as for pen. So according to that, you can search that exactly in which particular class your goods or services are there. Then statement as to use of a mark, means it is proposed to be used, the mark is used by the applicant, or it is predecessor in title, since it is, means sometimes it happens that we already starting use of the particular trademark and later we go for the registration. So according to that. Then priority claim, if you are already applied somewhere in other country, then that priority claim. Then any other information that you want to give. Then verification, means you have to declare that whatever the information provided is true to the best of knowledge. Then the detail of the person submitting with the signature and authority. So everything need to be mentioned through this. So forms are self-explanatory. You can fill the information and you can go for the registration of the trademark. So all learners who are interested to the start business, or who already are in a business, or they have the certain ideas about the trademarks, combinations of their mother and father name, or combinations of some words and symbols, or very typical different words, like suppose xyloid is the company who means they are involved in the wood business, wood, and xylem is the uh, terminology, scientific terminology related to the wood bark or that stem. So xyloid, so this is very different type of the. So in this way, here we have learned about the trademark registration or trademark filing. Now we will learn about the geographical indication registration. So similarly, we will start with the geographical indication registration search in a Google, and we will visit the official website of Intellectual Property India, where directly we have search for the registration process. So it has taken us to this particular tab, but in a IP India website, on a home page, we can see that there is a special tab given for the geographical indication, and under quick information we can go to the registration process. So first step is a filing of the application, where you have to must made the application in a triplicate. This application must be signed by the applicant or his agent, and accompanied by the statement of the case, means what is it is actually for what the geographical indication is filed. Then details of the special characteristics and how those standards are maintained. Then the copies of the map of the region, because geographical indication is related to the particular geography location to show the quality, hence that map is necessary. Certified map copies are also necessary. Then if there is any inspection structure that need to be mentioned. Then the if number of producers are there, then the collective addresses and the specific addresses that need to be mentioned in the register, that need to be mentioned in the application. And this application can be sent in a hard copy, means there are two ways. E-filing is also there, like that of the patent and trademark for the geographical indication, as well as the in person you can also file, or hard copies you can also file. So the office is that is of Chennai, geographical indication registry, intellectual property office building, that of the Chennai. Then it is very necessary that the applicant must have an address for service in India. Generally, application can be filed by the legal practitioner or registration. Step 2 and 3 is that is a preliminary scrutiny and the examination of the application, means whether application is correct, are there any errors, whether technically it is correct or not, that is evaluated by the examiners or the intellectual property office authorities. Then next it is the, if there are any error, if there are any objections, if registrar is thinking that it need to be corrected, then show cause notices, or that is called as the communication is given to the, communication is sent to the applicant, and then applicant must respond within the 2 months or come for the hearing. And if the applicant wishes to appeal for the rejection or whatever the comments has been given by the registrar, then he or she can file within the 1 month for that. Then next it is the publication. If it is accepted, then publication in the geographical indication journal, and after publication there can be the opposition to the registration. Every time there will not be the opposition, but whenever there will be the opposition, then such a notice will be given. Such a notice must be given within 3 months from the publication. Then registrar shall serve the copy of the notice to the applicant, means that after the getting that notice, within 2 months the applicant shall send the counter statement, and if it is not able to send, then it will be considered as a abdon application, means no action will be taken. Then if the counter statement is given by the applicant, then both sides, that applicants as well as the opponent sides, will be verified, and then either through the written statement or through the hearing, uh, this opposition to the geographical indication registration will be considered, and when it is accepted, then finally it will be considered for a registration. The registrar shall register the geographical indication, and then the date of filing of the application shall be the deem of the date of registration will be considered, and then the certificate with the seal of the geographical indication registry will be given to the applicant. Next step, it is the renewal. Then after the 10 years, it should be renewed with the payment of the renewal fee. Additional protection to the notified goods is also provided in the act. And step 10 is the appeal, means any person aggrieved by any order or decision may prefer an appeal to the intellectual property appellate board or to the high court within 3 months, and the address is like that of the same, that of the Chennai office. Then it is also mentioned that which indications or what indications are not registrable. If they are causing the dispute or cause confusion, then they are not registrable. Then which are contrary to the law or for time being in force, which are scandalous or obscene matter, or which can hurt to the religious beliefs of the people, which is also in case of the trademarks also that I have discussed previously. Then which words sorry which geographical indications would otherwise be dismantled to the protection in a court. Then generic names or indications of goods not or cease to be protected in the country, or uh, which although literally true as to the territory, region or locality which the goods originate, but falsely represent to the persons that the goods originate in another territory, region or locality, then that will also not be considered as a geographical indications. Explanation 1 to the section 9 says that for the purpose of this section, generic names of indications in relation to the goods which although relates to the place of the region where the goods was originally produced or manufactured has lost its original meaning and has become the common name of such goods and services as a designation for an indication of the kind, nature, type of other property or characteristics of the goods. So there are chances that made in India means if product is produced in the England territory and it is considered as a made in India or like that, such a confusing or such a appealing words will not be accepted. Then under the additional protection to the certain goods, the applicant may be made to the register in respect of the goods notified by the central government for additional protection for the registered geographical indication in form G I-9 accompanied a clip along with the statement of case and shall be accompanied with the copy of the notification issued. So, applicant shall mail jointly by the registered proprietor of the geographical indication in India and all by the producers of the geographical indication. So, there are chances that additional protection must be given so that there must not be the infringement, there must not be the improper use. Then these all documents of the geographical indication are always available for the inspection by the public. Then here it is mentioned the flow chart of the registration also, that filed application, examination, objection, then hearing, then refusion or acceptance, then advertisement in a journal, then opposition, then either it is refused or application is accepted, then it's entry in the register, and then its certificate is issued, and meanwhile there can be the renewal also. So this is the flow chart. Under this particular geographical indication, there is a list of the or classification of the goods. Here we can say that under the classification of the goods, they have given the certain classes. You can see that there are total 34 classes for the geographical indication. So class 1 is about the chemicals, class 2 is about the paints, varnishes and lacquers, class 3 about is bleaching preparations, class 4 is about the industrial oils and greases, class 5 is for pharmaceutical, veterinary and sanitary preparations, class 6 is about the common metals and their alloys, then class 7 for machines, and like that. Class 22 is for ropes and strings, nets, stands, then class 23 for ants and threads. So class 25 for clothing, footwear, headgear. So according to that, you can see that these 34 classes are mentioned for the geographical indication, and as per the requirement of the forms need to be filed for the application, you can fill the necessary information. That application for the GI 1A. So here you can see that the application is hereby made for the registration. So name of the applicant, address, list of association of person, producers, organization, types of the goods, means which type of the good it is, then specifications, name of the geographical indications if there are any particulars, description of the goods, geographical area of production and map, proof of origin, any historical records, method of protection, uniqueness if there are any inspections body, then the other type of the uh, information that need to be given. Then here it is one more, that is uh, C and D, where the falling in the different classes or falling in the different classes from the convention country, then the information need to be given. So thus with these forms uh, you can proceed for the registration of the geographical indication. Generally geographical indication cannot be registered by the individual, it is always by the group of the people, producers of that locality. So learners who have joined to this particular Swayam self-paced course, which is AICTE approved, they have to help the people, especially the tribal people, local people who are not aware about such intellectual property protection. So help them to register the geographical indications. Here also the list of the geographical indications that are registered is given, like that. Suppose this is the registered GI, means state wise it is given. So Madhya Pradesh Chanderi sarees, Maharashtra Solapur chadar, Maharashtra Solapur terry towel, Odisha, that is a Kotpat handloom fabric. From Karnataka it is handicraft, which is the, means these are the classes. Mysore silk, then Rajasthan Kota Doria handicraft. So these are the various geographical indications that are registered. You can see that year wise there is an increase in the registration. See, from Uttar Pradesh, Mahoba Gaura Patthar Hasta Shilp. From Uttar Pradesh, handicraft, that is a Mainpuri Tarkashi. So here are different in a means geographical and so many geographical indications in last year 2023 and 24. Year is also mentioned, state is also mentioned, class of goods from April 2022 through the March 2020. So nowadays awareness about the geographical indication registration increased, and you learners also help. Either you register, help them to register, or you yourself can do the registration. See, Maharashtra handicraft, that is a Savantwadi uh, Ganjifa cards. Ganjifa cards. Then from Madhya Pradesh agriculture, that is a Ratlam Riyavan Lasun garlic. It is a garlic. It is the agriculture. So generally agricultured or handicraft are more. Manufactured are also same some. Marua millet beverage, which is manufactured from Maharashtra. Most of the agriculture and the handicraft are there. So these are the example. Thus, I think that learners have got the sufficient knowledge that which forms are required, what information is required for geographical indication registration, and what are the classes of the geographical indications. There are 34 classes. What description is required, and how or to whom the forms can be submitted. I have told you that e-filing is also there. So here you can see that for the geographical indication there is a through the e-gateways of the IP India office website. You can see that under comprehensive filing there is a one tab which is the e-filing geographical indications, which will take us to the external website. And here again you have to first register. After registration, through the digital signature or through the e-sign, that is uh, Aadhaar card mediated KYC affiliate KYC complied sign, you can register, and you have to do the payment of the registration fee through the Bharat Kosh. So Government of India, especially patent offices, made the most of the procedures very easy. We can do it by our own. Just we have to comply with the all requirements, technical as well as the intellectual property related requirements. Thus here we have learned about the geographical indication registration. Now we will learn about the copyright registration, which is very commonly asked by the many of the students as well as the learners. So when we will type the copyright registration in a Google, it will take to us to the official website of the Copyright Office of India. There is a separate office like that we have seen for geographical indication, trademark, design, as well as for patent. There is a IP India website, but here it is a different office, different website, and the office is located in Mumbai, as well as the head office is in a Delhi. Now for the copyright registration is also there is a e-filing for the copyright application, and there are certain forms that are mentioned. It is already I have told you that there is a not there is no any necessary to do the copyright filing, because whenever you are working or you have created something, you are owner of that work, and copyright is uh, with you. But to get the certificate, to avoid the any further infringement or complications related to that, this particular copyright registration services are provided. Here you have to file the form, that is the 14. Then you have to file it with the signatures. You have to mention the details of your copyrighted work, like that, uh, whether it is artistic work, whether it is sound recording. If it is artistic work, then it is need to be uh, with the PDF or JPG format. If you are doing the e-filing, if you are submitting the hard copies, then it should be in the print form. Then sound recording in the MP3 format, literally dramatic music and software work need to be in a PDF format less than 10 MB. And then through the all details, through the payment from the payment gateway through the Bharat Kosh, then you can submit the application. Here is the checklist which is mentioned on the website itself, that the application is enclosed with the prescribed fee by the postal order or demand draft. If you are not doing the in e-filing, if you are uh, filing it offline or in person, then it is the through the demand draft. Then application form, that is form application 14, with all the requirements, all the particulars need to be filled correctly. Then there is a need for the uh, SOP or SOFP, whatever the subject matter is there, for whatever the copyright claims you are mentioning, for that you have to mention. Then name, address and nationality, then the title of the work, then the languages in which the work need to be get copyrighted, then the country of the publication if it is the convention application, then subsequent countries, and further the all details which are mentioned in the checklist, that you have to first, before submission you have to first check it. Okay, then that either hard copy or in person or through the e-filing, you can do the, you can submit it for the registration, for the copyright registration. Here you can see the status of the application, whether it is awaited, waiting, or documents not received, or if it is abandoned, means if the applicant has not submitted the required documents or not replied within time, then it is considered as abandoned. If it is under scrutiny or re-scrutiny, or it is pending for hearing, or if it is registered, then all the different type of the status you can go, you can see through the status of the application. The details of the processing fee, you can you can go through these details, that what amount of fee you will require. So 5,000 per work. Then broadcasting 40,000. So like that they have given the details of the fees. Here also the workflow is given, means how it works: filing of the application along with the fee, then issue of the diary number, or it is directly the application number, then 30 days mandatory waiting for objection. If objections filed, then if it is no objection, then it will be scrutinized by the examiner. If objections are there, then both parties will be asked for the reply to get filed, and then that procedures are there. And then final registration. Here FAQs are also given, that what is copyright, what is the scope of protection in the copyright, does copyright apply to the titles and name. Yes, not exactly to the titles or name, but generally the copyright is given to the title. Means suppose someone has written a book, then to that book title it is given. Is it necessary to register a work to claim the copyright? So I have told you many times in previous lecture also, that there is a no necessity. So acquisition of copyright is automatic, and it does not require the formalities. Copyright comes into existence as soon as work is created, and no formality is required to be completed for acquiring the copyright. However, Now this is the most important. However, the certificate of registration of copyright and the entries made therein serve as a prima facie evidence in a court of law with reference to the dispute relating to the ownership of the copyright. So it is very necessary to remember this. So there are many FAQs, you can go through this. These are the different FAQs. For more knowledge you can go through these all. So thus we have learned that how we can register the copyright. For copyright there is a special office of the government of India, that is a copyright office, which is having the uh, contact address from the Mumbai, the registrar of copyrights, and the deputy registrar of copyrights, that is a head office, it is in a Delhi. We can do the manual filing as well as the e-filing, and for that various forms and fees are mentioned on the website itself. So learners can do the copyright registration. And I have mentioned under FAQ also, it is given that there is a no registration to get the copyright is automatically obtained whenever the work is created by you, but for infringement cases, for the proof in a court matters, you need the copyright registration. So learners, in this lecture 30 case study 10, we have learned about the registration procedure for the patent, geographical indication, trademark and copyright, the various portals of the government of India for registration of this particular intellectual property rights, their forms, fees, their requirements, then how the e-filing works, then how there are the additional benefits for the geographical indications which are not implemented till date very effectively. These are restricted to the wines and spirits, but still most of the geographical indications are in demand of the additional benefits. We have seen that most of the geographical indications are from handicrafts and agriculture. Then in case of trademark also, there are various types of the trademarks, and the registration procedure is the same. Renewal fees of this trademark or geographical indication. In case of the patent also, there are the various forms, and according to the forms there are the various fees. Then page number or claim numbers if varies, then there is also the increase in the fees of this patent filing. So there are so many aspects, at least basics of these aspects of registration of the patent, geographical indication, trademark and copyright has been learned by you. Thank you.